Let's talk about wills. And one of the things I just said about wills is when you have a will, you're expecting a probate on your death. And if there's going to be a probate, the likelihood increases that a lawyer will be involved. And when a lawyer is involved who's skilled, who understands estates and probates, the likelihood of a successful estate plan increases greatly. By that, I mean there's not going to be estate taxes paid that shouldn't be paid. The assets are going to go where they should go, appropriately, fairly, like the person, the decedent intended. So you're going to get a better outcome often when there's a probate. One of the things people say is, you know what, I want to avoid a probate because I don't want people, other heirs or family members to know about what my revocable living trust says. And that's a really good point, that there is more privacy with a revocable living trust than with a will. So with a will, you have to give notice to what are called heirs at law and beneficiaries. That, however, doesn't mean that a revocable living trust won't be argued in court. The reason I say that is anybody who has a claim, who is a beneficiary and they think they're not being treated appropriately, or has any kind of gripe with how this trust is set up and being administered, the court's open to them. They have recourse through litigation in the court. So a revocable living trust doesn't mean you are insulated from a court action. Court actions occur whenever anybody has money to argue over, be it in a probate or in a trust situation, be it a trust administration at the time of death or later, if they're a trust beneficiary. So don't think that one or the other is necessarily going to be a better outcome by keeping people out of court. One of the things actually that's nice about having a will and a probate is we give notice to creditors during the probate process, and that includes heirs at law. So if an heir at law says, oh, I get more, or something's wrong with this, how this will is set up, they have a 4-month period. That's it, to bring their claim to the court and have it adjudicated. We deal with it right away. And if that doesn't happen, they are actually cut off by that claims procedure, that they cannot thereafter claim more money. In the revocable living trust scenario, there is that same notice to creditors process that's available. It's less likely to be used because people are trying to avoid any kind of court involvement, but it is available to help make sure that the claims are cut off early on within 4 months.